Now then, for more analysis on the Kenya ICC issue, we're now joined live in studio by Edigar Kavulavu. He's an advocate with the International Commission of Jurists Kenyan chapter. Thank you very much for your time this afternoon on Africa Live. So the chief prosecutor has essentially applied for a postponement of the trial. What happens next?
Well, this is not the first time that the Kenyan situation, there has been an adjournment in the Kenyan situation, but this basically means that the prosecutor wants to be given more time so that she can solidify her case. She had said that the evidence before the court does not meet the evidentiary threshold. Therefore, she needs more time at least to gather more evidence.
But as I understand it from the statement she released yesterday, she's essentially looking for an indefinite adjournment. Now, in the first place, how likely is that to be granted? And second, wouldn't that, in a certain sense, be a denial of justice to some extent to the Kenyan head of state?
Well, the case cannot proceed without enough evidence in court, because the ICC is a criminal court, as it were, and it really relies on evidence, and the threshold of the evidence is very important. And also you realize that one of the principles of international justice is fairness for the accused person. So it would be unfair for the accused person to proceed in a trial whereby the evidentiary threshold has not met the threshold.
But couldn't the argument be made that the prosecution office has had several years, really, to gather the evidence they require, and at this stage in time to then ask the court to go back again for more time? That in and of itself is a bit of a problem.
Well, given the developments in the Kenyan situation, the prosecutors on several occasions complained that there has been meddling, witnesses have been meddled with. So given that development, it is highly likely that the prosecutor will make such an application.
Do you see this vindicating the arguments some have made, especially in criticizing the means and the methods used by the prosecution office to gather evidence and prepare for these two trials?
Well, I won't say that it has vindicated them per se, because the right forum to weigh and measure evidence is the court. And I don't think other spectators will really want to measure the evidentiary threshold of any evidence that is presented before the court.
Finally, Mr. Kavulavu, the Kenyan justice system has failed the victims of the post-election violence, and so far there hasn't been any concrete result from the ICC. So are there really any alternatives beyond the ICC for the victims of the post-election violence?
Well, that is a situation that we remain to see as a country, because currently Kenya is in the process of putting in place an international crimes division, and if that goes through, then I think it will give the victims some sort of reprieve. We have already gone through the quite other processes, for example, domestic prosecutions, but which have failed. But again, you realize that the international court is a court of last resort, and the buck stops with us as a country to ensure that these victims get justice.
Indeed, we'd love to leave it there for the time being. Thank you very much for your time this afternoon. That's Edigar Kavulavu with the Kenyan chapter of the International Commission of Jurists here in Kenya.